Marco Rubio says U.S. visa holders not protected by First Amendment, points to Supreme Court rulings. U.S. Secretary of State Marco Rubio said that visa holders or aliens referring to immigrants cannot use the right to free speech under the First Amendment as an excuse to support foreign terrorist groups like Hamas, Hezbollah, or the Houthis. In an opinion piece published on broadcaster Fox News website, the U.S. Secretary of State wrote the Supreme Court has made clear for decades that visa holders or other aliens cannot use the First Amendment to shield otherwise impermissible actions taken to support designated foreign terrorist organizations like Hamas, Hezbollah, or the Houthis, or violate other U.S. laws. They will continue to face consequences including visa denial, revocation, or deportation. The opinion piece was published as the administration of U.S. President Donald Trump deports students who were seen participating in anti-Israel protests and were seen engaging in acts of so-called activism that were deemed sympathetic to Palestinian militant group Hamas as the war in Gaza continued. An immigration judge ruled Friday that a pro-Palestinian student protester, a U.S. permanent resident detained by the Trump administration, can be deported, his lawyer said. Assistant Chief Immigration Judge Jamie Comins, based in the state of Louisiana, said the federal government had met its burden to prove it had grounds to deport Mahmoud Khalil, according to a statement by his attorney. Immigration officers have similarly detained and sought to deport a Tufts University student from Turkey, Rumisa Öztürk, and Columbia student Yunseo Chung, who is a U.S. permanent resident originally from South Korea. Their deportations have been blocked for now by courts. Rubio wrote in the opinion piece that he would continue exercising his authority to support U.S. President Donald Trump's zero-tolerance approach to foreign nationals who abet terrorist organizations or participate in activities that threaten our national security or compromise a compelling foreign policy interest. Over the years, the U.S. Supreme Court has sent a mixed message on whether people who hold U.S. visas, like students, workers, or tourists, actually have the same right to free speech as American citizens. In some cases, the court has said yes. For example, in Bridges v. Wixon 1945, it protected a legal immigrant from being deported just because of his political beliefs. But just a few years later, in Harry Sides v. Shaughnessy 1952, the same court said that even a legal resident could be deported if they had previously been part of a group considered a threat. In this case it was the Communist Party, which went on to show that political views could still become a reason for removal. The pattern continued in Kleindienst v. Mondell 1972, where the U.S. denied a visa to a foreign scholar invited to speak at American universities. The court said the government had the right to decide who gets in, even if U.S. citizens wanted to hear what the speaker had to say, according to a release by the Legal Information Institute. In a 1999 case, the court backed the idea that even peaceful political associations could be a reason to deport someone, not because they did anything wrong, but because of who they were linked to. Swipe left for next video. The case involved the U.S. government's attempt to deport 8 non-citizens, 7 Palestinians and 1 Kenyan, because of their political associations. They were targeted under a Cold War law, the McCarran-Walter Act, for being linked to a group that supported world communism, which was then grounds for deportation. The U.S. government of the time had admitted that none of them had committed any crimes or engaged in terrorism. They were being deported solely because of their political beliefs, distributing related materials, talking to others in the group and raising money for humanitarian causes, according to a press release by the American Civil Liberties Union ACLU. U.S. visa holders should know in no uncertain terms that the U.S. government's rigorous security vetting does not end once a visa is granted. Working together with DHS and other law enforcement and security agencies, we continuously monitor and review these cases, Rubio wrote in his opinion piece. Latest blogs.